Okay, right from the start, you can feel how messy this situation is. The guy is supposedly evicted, but he's still living in a unit, and no one seems to know who's paying what. The landlord's scrambling to explain repairs. Mr. McKenzie is defending himself, and there's a constant back and forth about a bathroom. That's actually central to the dispute. And the craziest part? Permissions were only given orally. No paper, no receipts, just trust me statements. I mean, who keeps track of this in court? But here's the human side. Imagine your bathroom is unusable and you're supposed to move while repairs are ongoing. Stress level, maxed out.
You don't know that information from your client?
I don't know the exact specifics. I just know when it was supposed to have been completed by.
Well, supposed to and
This
when.
is where things get wild. Drywall, mud, painting, basically your entire bathroom is being torn apart. And because of a leak, the washer and dryer are ruined. Water spilling, holes in ceilings. It's like a home renovation horror story, but now it's court. You start to see why Mr. McKenzie might feel justified holding back rent. But at the same time, from the landlord's perspective, they're trying to get this done and the tenant isn't paying. It's a perfect storm of frustration on both sides. And the timeline confusion? That's exactly why these cases drag on. Nobody can pin down exactly when things happen.
Video with you when I told you the first time the water splashed on me.
Okay.
The time when it splashed on them, it came over.
Okay, just a moment. Mr. Katz, are you familiar with that?
I'm not familiar, but Your Honor, I do have to ask the procedural issue because here's what I'm sort of confused as it relates to this.
Now the judge steps in and suddenly the room goes quiet. Legal logic doesn't care about your feelings. Abatement, escrow, current versus old unit, all of it matters. Mr. McKenzie is explaining why he hasn't paid, but the judge is pressing for proof. This is the moment where you realize how personal frustration meets legal reality. You can feel Mr. McKenzie's anxiety, but the law isn't subjective. It's about documentation, timing, and process.
How much money do you have set in that separate account?
The separate account is $7,000.
Your Honor, if I can.
We were about to get it shown.
When we were here in August, you asked to send me. You said he has to send me a copy of his escrow account. He didn't. We spoke in court the next time. You said send him a copy of the escrow. He didn't. I sent him an email on September 12th. I followed up on my conversation with.
Excuse me, just one moment. Did you respond to the email? Excuse me. Excuse me. Let me finish my question. Did you send a response to Mr. Katz's email with proof of the rent money sitting in a separate account?
I just said no.
Okay.
Because he didn't send me an email that you can't respond to something that no.
All right, counsel, I'll take a look at that email. First, you have to show.
I'll show it to Mr.
Well, no, my court officer will do that. Thank you.
Then there's this email that never existed. Classic court drama. The tenant claims he didn't get it. The landlord says he sent it. Everyone's digging through inboxes. This is a human story as much as a legal one. Communication breakdowns have consequences. Viewers can instantly relate to the stress of trying to prove you're right while everyone around you is confused.
It's buffering to get to.
Finally, the numbers. $13,000 owed across units, late fees, extra charges. When you see it broken down, it hits differently. Suddenly, it's not just a messy bathroom. It's a real financial impact. You understand why the landlord is firm and why the tenant is defensive. Money and principle collide, and it's tense. You can almost feel the weight of every dollar hanging in the courtroom.
Mr. McKenzie, did you pay rent for the month of June? Are you on your phone, sir? Or are you still looking for the email?
I'm looking for this email that don't exist.
Well, it exists, sir. Whether or not you received it is my question. That's why I wanted you to show my court officer there, but I don't know if it's continuing to buffer. What date are you on?
We only back 4 days.
Oh, okay. Wow. Sir, let me ask this question. Let me ask you. I'm not questioning whether it's buffering. Okay, please keep your hands out of your pockets. Did you pay rent for the month of June?
I paid rent when we first moved in.
Did you pay rent for the month of June?
No.
Did you pay rent for the month of July?
No, I didn't pay any rent except for the first month when we got there because they never fixed anything.
Okay, so, sir, it is your responsibility per the law to show the court and your landlord that you are depositing the rent in a separate account. That is what the law requires.
Yes.
You have not done that. I'm not questioning whether or not the repairs were necessary or not. They clearly were necessary because they were made. They were made. You did not submit proof of the escrow amount as you are required to do.
And they didn't fix anything as you told
Sir?
me they were required to do.
Sir, just let me,
Yes, sorry.
they did not fix what they were supposed to do. They finally did it in September. That does not negate your responsibility for showing proof that the money is deposited in a separate account. Had you done that, we wouldn't even be here. Because you have that requirement. It's a legal requirement that legally allows you to withhold payment of rent for repair issues. You did not submit proof of that. And the court will also note that July 25th, on the prior case, 2501234 LT, that you claimed many repair issues. We set it for a second hearing August 11th at 8:30. On August 11th, there is no agreement on the amount owed. Plaintiff claimed 5151 was owed. We set it for an in-person hearing August 22nd at 11 a.m. The court also on August 22nd stated that there was a hearing, there was information gathered. Parties were to return September 15th at 11 a.m. Defendant to be included in any communication regarding scheduling to look at the apartment and repairs to occur. Defendant to submit proof of rent money held in account and activity of deposits by August 27th. Did you do that?
And
Okay. Then on September 5th, and everybody was supposed to return September 15th. Oh, sorry. Also on August 22nd, Gold Star Restoration was to be at the apartment that day between 12 and 5, and the court had ordered the parties to go in the lobby to determine if they'd already been dispatched to the apartment, because I recall that that was a concern that had occurred. Now, then let's move to September 15th. Mr. McKenzie, you were not present. Also, you had not shown proof of the money escrowed by August 27th. The representation on September 15th was that all repairs have been made and near completion. Drywall being completed September 16th. That's when the court entered a default judgment of $6,856 with a writ of September 25th. And the abatement was not addressed as you did not appear and you did not speak with plaintiff counsel regarding any abatement. Sir, had you appeared, the court would have known
that they didn't fix.
that it wasn't finished. Because the court took what counsel represented. Now, whether or not counsel spoke with their client ahead of time, I have no idea. The court has to go with the representation as an officer of the court that is all being done. Further, the court then, so there was a judgment entered. Appropriately, there was a judgment entered because you weren't here, sir. I don't know why you didn't show up, but you weren't here.
That's what I was talking about in the last Zoom. I didn't show up because I had asked if we could change to another day. And you said no. And I said I had to work that day because I drive long. So I couldn't be here because I was out of the state. And I remember saying that I was like, can we please do it another day? On the Zoom, you said, how come we didn't do it on Zoom? And I said, I don't know why we didn't do it on Zoom. But you said we had to be here that day. And I couldn't make it that day. And I let you know I couldn't make it that day.
Sir, when did you send something in writing? Because listen, I have hundreds of people that speak to me in a day.
Oh, no, I didn't.
Hundreds of people that speak to me in a day. Okay. And so I
I didn't.
While I have a fairly good memory and recollection of many things, I don't recall every single conversation with every single person. You were not here on that date. You didn't even Zoom in or anything. Okay? So the court entered a default judgment.
Right.
Clearly, there was a misrepresentation or misunderstanding somewhere because the repairs were not done as counsel represented they were.
I had talked to him.
In any event, sir, you did not show proof of the money deposited in escrow. Had there been proof submitted to plaintiff counsel would have been required to notify the court, show the court, and the court likely would not have entered a default judgment against you, sir. But that didn't happen. And now you're occupying another unit and not paying rent and not showing proof of that money sent into escrow. So, sir, let me also clarify something. Back in July and even August, I could have ordered you to submit that escrow deposit with the court. And if you didn't, then there would have been additional violations. Counsel, you on your phone?
I'm just checking the date, Your Honor, because
The date of what?
Your Honor, I'm almost certain that when we scheduled the date with Mr. McKenzie for that September, what was it, the 15th?
15.
You actually chose the date because Mr. McKenzie indicated what were the best dates for him. Okay?
I would agree. I'm pretty sure I did.
We modified the court dates specifically based on Mr. McKenzie's AM, PM, and whether he was working that date. So Mr. McKenzie says that he told the court that he wasn't available. I am certain, Your Honor, that on the date that we scheduled, it was scheduled with him in mind and with his schedule in mind.
I agree. I would agree with that because I was being very careful to make sure that Mr. McKenzie was able to be at these hearings.
I asked you about that day. I said, can we do any other day? And then you said no. Now, on the last Zoom we had, you said, how come we didn't Zoom? I Zoom when you say Zoom. I come in when you say come in. So if you didn't tell me to Zoom that day, it's because I don't know why. But I have certain days that I drive. That was a money day. So I absolutely know that I came to you and told you that before. Why would I miss that? There's
Okay.
no way that happened. So,
Sir, let me just clarify. I do recall that when selecting these dates and times, the court did take into account your work schedule.
I know exactly why, because when I was going to show up to at home, every time they were supposed to come out and fix things, it never showed up. You said, you talked to them, how come they didn't show up? And I said, I'll be missing days of work to stay home waiting for these people to show up, because that's when they said, we don't know when they show up. They just show up when they show up. That's literally what they said. And I said, I stay home from work and miss work waiting for these people and they never show up. And you tried to make an accommodation and I did everything.
All right.
I said, but that day is Mondays. It's a money day that hasn't changed in 4 years.
Sir. Okay. Irrespective of all of that, your legal requirement of showing the money deposited into a separate account has not been met. And further, I even ordered that you had to show proof of the deposits that had been made to show that every month you were depositing money into this account in lieu of paying rent. You did not do that.
So when
Sir, you did not do that.
I said, no, I didn't. No, I didn't. You're right. And you told us that if we came to an agreement, that we wouldn't even have to come back here. I called him, told him that when we were going to be out, and he said, okay, just show me that thing that you just said, the paper. I said, fine. That day came for the 15th. I called him before that. Now, this is what we had a disagreement with outside in the lobby. On the day that I was calling, he had a message that says he wasn't returning calls or texts or something like that. I called the manager. She called. and said, well, he's not answering available. Same message that I got. She said, I'll let you know, but I want to call my boss.
Okay, sir, hold on just a moment, please. Just a moment. What date is all this occurring? This that you're talking about right now, what's the date?
Exact date.
Well, I need to know that because
It was-
from August 22nd until September 15th, I'll tell you that was, I'm sorry?
It was between then, before the 15th, and this is the reason why I was saying that. The reason I called him to make this agreement is because I knew I was not going to be there on the 15th. That's why when he says, oh.
Sir, just one moment. Please listen to what I'm saying. There's 3.5 weeks in between the court dates.
Yes.
So in 3.5 weeks, you did not send that to Mr. Katz.
No, I didn't.
Okay. So, sir, that is the whole crux of the entirety of the case at this point. There is zero doubt that there were repairs that need to be made. The court also doesn't have any doubt that those repairs were made while you were the tenant of that property.
Yes, that never made while we were.
Okay, and you never showed proof of your deposit,
Right.
which you are required to do.
Yes.
So therefore, the court doesn't have any legal basis to not grant the plaintiff's motion or the plaintiff's request for judgment, sir.
So if I was to bring it in or mail it to you or give it to him, to y'all both after this, what would that do? Would that make it to where my problem that I have now is that default judgment put an eviction on my record and I can't move into somewhere else because they see the eviction from this place when I should have been evicted, when they never fixed anything. My house is like construction.
Sir, then you should have followed the court order. You should have followed the court order and sent proof of that to Mr. Katz.
They didn't
And
follow the court orders either.
sir,
And I'm the only one getting punished.
sir, the property has now been repaired.
It's not.
The one, unit 201 is what I'm talking about.
They still.
201 appears and is represented to have been repaired. Now, if you wanted this court to take into account abatement amounts, as it was going to do, then you needed to submit proof of the deposits of the rent to Mr. Katz. You did not do that. And in fact, the court ordered that on August 22nd, sir. August 22nd, the court ordered that. You did not do that. You did not do that in August, September, October. And now here we are, November 14th, for an in-person hearing, and you don't have the documentation with you yet again today. So, sir, while the plaintiff's potential for having a violation of a lease for not repairing the items, that's a separate issue as well. What we're here for, sir, is that you did not pay rent. Show proof of your unpaid rent being deposited into a separate account. That is how you are legally able to not be responsible or not be evicted for that purpose. You did not do that. 4 months. 4 months, you have not done that. So, sir, that is why this court has to enter a judgment against you for non-payment of rent. Because at this point, it's the plaintiff's inability to repair their units timely is not as much of an issue at this point because you did not show the proof of the escrow accounts. And that, as I stated, is the only way that you can legally withhold rent. And that did not happen. And sir, there were multiple opportunities for that to have been shown.
You're right. Thank you for giving me those opportunities, and I didn't show it to you, and I was upset, and I'm still upset, and I wasn't going to. I should have brought it to you, like you said. I'm sorry about that.
Now, sir, let me also be very clear that because there's judgment that's going to be entered against you, doesn't mean that this court doesn't have concerns about the plaintiff having things repaired timely. Okay, that is not the case. But as I stated, the only way that this court could not rule in favor of the plaintiff is had you shown that. So the court is going to enter judgment for plaintiff.
And your Honor, do you think that helps? Because the old balance is irrelevant. My client would have to file a separate case.
So this is only for October?
This is for actually October and November for the current unit, which they indicated to him. They posted the amount he would have to pay if he remained in that unit. The monthly rate on that unit is $2,500. So he owes $5,000.
The monthly rate is $2,500?
Yeah.
Hold on, just a moment. Counsel, how is it $2,500 when the unit right above it is $1,499?
Because he has no lease, Your Honor, and basically he was not provided access to that unit other than the bathroom. So there was a notice that was put on his door that said, if you remain in this unit, you will be obligated for $2,500.
Okay, can I see that notice, please?
And I showed it to
Terry, can you grab that, please?
Yeah.
He saw it.
Well, hold on a moment, counsel. When did the new tenants move into 201?
The new move into 201. Actually have the date of that. 10/27.
October 27th.
Correct.
And I believe your statement was that the bathroom wasn't completely finished until after the new tenants moved in, correct?
No, until after they moved out of the final painting and final work and cleanup of the unit was done after October the 6th, Your Honor.
Okay, well, counsel, I'm not going to authorize $2,500 per month because this states, this notice is to inform you that the temporary use of apartment 101, which was granted solely for bathroom access during the restoration of the bathroom in apartment 201, is no longer authorized. As of today, the bathroom in unit 201 has been fully restored and is fully functional. It was not fully restored. Not by a long shot was it fully restored. So this is not, the court's not going to authorize $2,500 a month. So the court will go on the same rent as it was in 201, which is $1,499 a month plus the $130 a month in extras, correct?
Correct. Plus the late fees since they're paid.
So $1,629 times 2 months is $32.58 plus the late fees of $200, $34.58. Correct, counsel?
Plus, yes, cost of $180.
$180 for court costs.
It's 38.
$3,638 is the amount, the judgment.
Your Honor, the stuff that was supposed to be fixed upstairs at our old unit is still not fixed because the water is still leaking down to where we are now. And I wouldn't say nothing about it if it wasn't that I called Riverview Housing Department because they had to come do an inspection because there is mold.
Did you submit that in writing to the plaintiff?
Oh, no, those are the videos he just saw. And
Did you submit, sir?
I didn't write nobody, but I did.
I believe in your lease, if you look at your lease, you need to submit repair requests in writing. I would presume. I think that's typical of any lease, but I don't know this particular one. So I understand you may make a phone call.
Yeah.
But.
So then they do the thing. Or ticket, they call it.
Emailing is probably the most effective way to make sure that there is a chain of communication. But again, sir, you haven't put any money into escrow. So even if you notified them on the new unit that you moved into that there was a repair issue, you are still required, if you're withholding rent, you are required to notify them you're withholding rent and proof of the escrow account, right?
Yes.
And that didn't happen.
Yes.
I'm already not assessing the $2,500 per month because that was a misrepresentation. The unit was not fully restored. And nor was it anywhere close to being done when the parties were here back on September 15th, indicating all repairs have been made and near completion, drywall being completed tomorrow. So apparently, near completion is a subjective definition. Because counsel, let me be very clear. Had I been informed properly that the repairs were not all finished and not near completion, it may have been slightly different. So as counsel for the plaintiff, it's your responsibility, counsel, to communicate with your client to get specific information. This court requires details, specific information. Even as simple as having the names of your witnesses to tell the court. The court's going to order, after hearing that the judgment is for the plaintiff, $3,638. If the amount is not paid, defendant does not move out on or before November 24th, plaintiff will apply for an order evicting the defendant. Additional money may be owed if damage to property occurs or rent continues to accrue. Partial payment will not prevent the court from issuing an order evicting the defendant. No money judgment at this time. Good luck to you both. We'll make sure you get those back, sir.
Your Honor, do you want the copy of the judgment, or do you want me to just submit it in my file?
You can submit it via my file.
Thank you.
Thank you. Good luck to you both.
Enjoy Mr. Borkin. He's handling what's messed up.
Yes. What's that?
Sorry, forget what I said.
That's fine.
It's fine. You're fine.
Sorry.
Oh, you're fine. Thank you. Let's go off the record for a moment.